welcome to the May edition of HR Hot Topics. I'm your host, Jodi Schafer, and my aim is to make this the most informative 5 to 10 minutes a month. This month is a big one, folks. I sort of prepped this in April, letting you know that we were watching several pieces of, they weren't necessarily legislation, but proposed rulemaking. We're waiting to see what dropped. As you all know, the Biden administration has been very, very busy since they've taken office. And as an employer, it's resulted in significant increases to the amount of regulations that we now have to follow. Back in December of last year, I brought to you changes that came about as a recent National Labor Relations Board ruling that had a big impact on workplace policies, a lot of common policies that have been in your handbook forever, like code of conduct and social media and confidentiality policies, et cetera. And then in February of this year, I brought to you the changes to the independent contractor rule and the minimizing of who could be considered an independent contractor. And then, as I said last month, I informed you that we were waiting for the Department of Labor to issue their final rule around the earning threshold for your exempt employees. And on April 23rd, they did exactly that. So the DOL has announced their final rule for those earning thresholds, and they are significant. So I have some notes here because there's a lot of numbers involved. So right now, in order to be considered an exempt employee, and in colloquial terms, we refer to those individuals as salaried, you have to meet the duties test. So it's based on the type of work you do. You have to be paid in a salary mode versus hourly. And then there's this earning threshold. You have to earn above a certain amount of money. And you have to meet all 3 of those criteria. This new DOL rule does not touch the duties test. It does not touch motive pay. It focuses only on the earning piece. So right now, in order to be considered salary, you have to make at least $684 per week, which equates to $35,568 a year. And this dollar amount was last increased in 2020. As of July 1st this year, that amount is going to increase. And actually, the way this new rule came out is they're doing a tiered approach. So it's going to increase once in July, and it's going to increase again in January of 2025. So the July 1st amount is moving up to $844 a week, which equates to $43,888 per year. So pretty significant jump there from now to July. And then on January 1st, 2025, it's going to increase again. And in January, it's going to go to $1,128 per week, so almost double what it is right now. And that equates to $58,656 per year. So very significant increases. And then it will, the rule is set to readjust every 3 years thereafter, starting in July of 2027. So the idea is that not only are we going to increase the earning threshold, which we've been doing over time since 2004, but now we're going to put in this automatic recalculation and adjustment every 3 years thereafter. So one other thing that increased, I got like a fuzz or hair in my mouth here, I can feel it as I'm talking, was the white collar earning increase. These are kind of your highly compensated employees. Those rates have gone up too. So I just want to make sure while I'm mentioning dollar amounts, I give you those. Right now, if you're earning above $107,432 a year, you could potentially meet that highly compensated threshold. Again, assuming that your duties match. In July, that's going to go up to $132,964, and then again in January, it's going to go up $151,164. So both of those thresholds are climbing. Where does that dollar amount come from, right? This is sort of interesting. I'm going to give you a little history here. So it's actually a percentage of weekly earnings. So what the government does is it looks at the Bureau of Labor Statistics data. It looks at full-time salaried employees across the U.S. It looks at the lowest earning region of the U.S., which right now is the South. And it picks a certain percentile of earnings. Now, historically, the earning threshold that they look at is sort of 20%. So back in 2004, when they did the update, they looked at full-time salaried employees in that lowest earning region of the U.S., and the 20th percentile of earnings, that's where they set that earning threshold. In 2016, the Obama administration wanted to increase this earning threshold. They looked at the 40th percent, and it underwent significant legal challenges and never ended up being adopted. In 2019, the Trump administration recognized that the current rate was woefully low, and so they suggested an increase, but they also looked at the 20th percent, and that's where the current earning thresholds sit. That was enacted in 2020. This newest update from the Department of Labor, it's interesting, right? It's that tiered approach. So it's looking at the July increase. The July increase is closer to the 20th percent, which historically has been upheld by the courts. But the January increase, that's at the 35th percent. So we'll see what's going to happen here. Expect there to be legal challenges to this, just like there was when the Obama administration tried to set it at the 40th percent. So I think there will probably be challenges around what percentile is used. And perhaps that's why the Department of Labor did this stair-stepping approach. Maybe the idea is that the July increase will hold, even if the January increase is deemed, too much. So at least they get some increase. I don't know. We'll have to wait and see. And another part of that challenge will most likely revolve around this 3-year automatic update. And does the Department of Labor have the authority to basically implement a new law without going through that proposed rulemaking process and do this on a proactive basis every 3 years? So we'll have to wait and see. Things that you should be doing now, though, that July 1st deadline is right around the corner. That dollar amount will most likely be upheld. So if I was a betting person, I would be taking a look at my current salaried employees and what they're making right now. And I would key in on that July number. So again, just to remind you, the July number is $844 a week, $43,888 per year. So I think you want to take a look at all of your salaried employees right now that are currently earning less than that and determine what you want to do. You could increase pay above the new earning threshold if you wanted to keep them salaried. You could change their classification from exempt salary to non-exempt, which means they're now eligible for overtime. If you have employees that don't work a lot of overtime and it's not going to be a significant cost to you, because remember, overtime is paid at time and a half, anything over 40 hours. So if you have salaried staff right now, but you take a look at how much they're generally working and there isn't a huge overtime liability, you might just simply flip them to non-exempt. In other words, hourly. You take their current salary, you divide it by the number of hours they typically work. Usually it's 2,080 hours for a full-time employee. You'd get the hourly equivalent, that rate, and maybe that's what you pay them from here on out. So it's really not a change to their pay, but if they do work over 40 hours, they'd get time and a half. And then there is another category here. It's not explored a lot, but I just want to put it on the table for you all. You could have an employee who's classified as non-exempt, which means they are eligible for overtime. But rather than paying them an hourly amount, you could pay them a flat salary. The salary could be anything you want it to be as long as it's above minimum wage. So you could potentially keep their pay exactly the same as it is now, continue to pay them that flat amount every week in a salary, but you'd have to have a way to track overtime. Because if they do get more than 40 hours in a given week, you would have to pay them the time and a half for those extra hours. But if they work less than 40 hours in a given week, you don't necessarily have to take pay away from them. So there is that sort of non-exempt salary hybrid option too. So if you need any guidance or assistance with that, obviously we can help. The next thing I want to share with you, I'm going to switch gears here. The next thing I want to share with you is something else that happened on April 23rd. Again, the 23rd was a big day. We got this new ruling from the Department of Labor that we'd been waiting on, but then we also got the final rule from the Federal Trade Commission banning non-competes. What? So we knew this was coming. We had seen the proposed rulemaking from the Federal Trade Commission months and months ago, and then they accepted all of the comments, and then we heard nothing, right? We were supposed to see this new rule come out much sooner than it actually did, and they sort of held on that. I think there was a lot of debate because the new rule that came out was voted in along party lines. It passed 3-2 on the commission. So not everyone on the commission is in agreement with this, but majority rules. So here we go. Federal Trade Commission basically banning most non-competes. There's a small number of exceptions here, so I'll just go through this. This is set to take effect in late August. So the way that things work when you propose a new rule is that from the time the final rule is published in the Federal Register, it takes effect 120 days after that. So we're looking at late August for the kind of the earliest that this would take effect. This is a federal rule, just like the Department of Labor earning thresholds was a federal rule. So this would supersede any state rules. And it basically bans all non-competes, not just newly created non-competes. This isn't a go-forward rule. This is any non-competes currently in effect. So any past non-competes for former employees that are still in effect, those would become null and void as well. There are a few exceptions. I want to make sure to share these with you. Any non-competes that were in effect for senior executives, and a senior executive is defined as somebody making more than $151,000 a year who sits in a policy-making role. Potentially those that are currently in effect right now could continue to run their course, but no new ones could be created. So it sort of does that halting on a go forward for senior executives. The small, sliver of folks that could actually still potentially have non-competes in place are non-competes that are part of a business sale or the selling of an ownership interest in a company. In those cases, you may still be able to have non-competes as long as they meet certain criteria. And then just a reminder that the Federal Trade Commission, which is the enforcement agency behind this, doesn't have jurisdiction over all industries. So if you're in the nonprofit industry, if you work for an airline, if you work for a bank, a credit union, an insurance company, for example, this would not apply to you because the Federal Trade Commission doesn't have jurisdiction over your industry. So what do you need to do? What do you need to be watching for? In this one, I would say it's a good idea to do an audit of your current non-compete situation. 1, do you use them? 2, what is the wording of those non-competes? Have an attorney look at that with you because non-competes are legal documents. So this is not something that HRM would help you with. This is something you'd want an employment attorney to help you with, preferably the individual that wrote the non-compete in the first place, and have them look at it through this new lens. Because if this goes through, and I say if because there are already legal challenges to it, but if this goes through, you'd want to know which changes you may have to make, if any. And then the final thing is, if you're using non-competes, who's currently under one, right? Who's still kind of under those old rules? And what would you have to do with those individuals? Are they a senior executive? Could you let that ride? If not, you may have to consider them null and void. Now, I say legal challenges because the U.S. Chamber of Commerce and several other businesses joined together and filed lawsuit against this the very next day. So on April 24th, they submitted their claim to a court in Texas. They have to have their briefings in by mid-June, so we'll wait and see. I don't know where this one's going to land. I can tell you that the Society for Human Resource Management, which is my professional association, submitted comment at the time that the initial rule was proposed saying, look, this feels very extreme, this blanket ban. Employers have to have the ability to protect trade secrets and protect their company interests. And could we have more specific language that you could have non-competes for these types of positions or for people that earn over X amount or right, some of those descriptors, and none of that was taken into account, just blanket ban. So we'll see, what the courts decide on this. I expect there to probably be some movement, but again, August is that date that we're looking at. That would be the earliest that the ban would take effect, assuming that there's no court injunction or hold placed on it before then. So again, if I'm sitting in your seat in this case, I'd be watching those rulings very carefully. But in the meantime, start kind of putting together your plan B. Look at your non-compete document, have your attorney review it, figure out what would need to change, if anything, if this goes into effect, or who those non-competes could be given to. And then think about alternative strategies. So this bans non-competes. It doesn't ban non-solicitation agreements. So if an employee were to leave your organization, you can still have an agreement that says you can't poach our existing clients for a certain amount of time. It could have non-disclosure agreements that say, when you leave our organization, you can't take our trade secrets with us. You can't reveal confidential information. You can't take client lists with you. Those are all still allowed. And often those are components that are built into a traditional non-compete. So if non-competes go away, you would want to have a secondary agreement drawn up that still has those components in it. So it's not that you can't protect your business interests, you just can't do it in the way that we've been traditionally doing it. And then the final thing is communication strategies, because the other part of this ban is that for individuals that have non-competes in effect right now, if the ban goes through and those non-competes become null and void, it's incumbent upon the employer to notify those former employees that the non-compete is no longer in effect, and you have to do so in writing. So kind of thinking about some of those communication strategies would also be important. What are we at time-wise? Well, like 20 minutes, 16 minutes. Okay, it's important stuff though, folks. These are really big shifts. Again, not the first time we've seen a big shift under the Biden administration, but these two happen to hit on the same exact day. End of April was a really big month. I told you it was going to be. So now you know a little bit about what was in store. I'll put lots of resources and links, as I always do, in the email message. But of course, if you have questions, you can email me directly, Jodi Schafer at workwithhrm.com.